So I was worried about being here tonight because all the flights back to New Jersey were being canceled because of like storms and things like that. So this is a rare time where I'm using the voice projector because we got back in last night around 2 o'clock. So my name's Ken Burkham, and both of my kids graduated high school here, and it was this week last year my son got inducted into the South Brunswick Athletic Sports Hall of Fame. So he's blessed that he's a much better athlete than his father was. So, but a lot of times we're talking about, people always ask me, hey, Kenny, why do I need to have a will? You know, people that when I'd be assistant coaching and soccer or going to different events in South Brunswick, why do I need to have, doesn't everything go to my spouse? He goes, yeah, but that's doing planning. That's like not having homeowners insurance because you're pretty sure that you're not going to have a fire or any kind of disaster. That's ignoring the inevitable. So if someone doesn't have a will or it wasn't done right because they tried to do it themselves, number one, the procedure to distribute assets becomes much more complicated. And that means that if there's no will or it wasn't signed properly, then it's called an administration. All the beneficiaries has to sign a renunciation and say, I won't do it, in front of a notary, pay a fee to have it filed. And that's for people where everyone gets along. A lot of times there's always one person that says, no, I'm not going to do that. And that means that it got to go, a complaint order shall cause in front of a Superior Court judge. And then spending thousands of unnecessary dollars. Then, if there's no will, the person who becomes the administrator has to take a surety bond, which costs a couple more grand. And so the people who don't do a will, they're saving money for themselves, but in a way they're kind of screwing their family. So, having a will done is not that complicated. And so we're going to explain in the 35 minutes or so, 40 minutes, some suggestions for you. Because you want to be able to determine who gets your stuff, not the government. And more people are not leaving money to their kids, not because they don't care about their kids, but they go, hey, listen, my kids have their own house. I'd rather have it put away for my grandkids so there can be some money for their education, because nobody thinks about college, education when there's young children. I remember, one time I went to this college, University of Scranton, and I love Scranton, I love their events, and one time I go to my wife, and goes, and our kids were probably in like grammar school at Indian Fields, and I go, I'm gonna give Scranton like $2,000 this year. My wife goes, yeah, how much have you put away for your own kids? Nothing. She goes, you're gonna give a total stranger $2,000, but you haven't put away a nickel for your own kids. He goes, well, I guess since you put it that way, I guess Scranton's not getting $2,000. So part of it, think about who you want to get your stuff, who you don't want to get your stuff. I'd say who might not be the right person to get assets right away. And you want to be able to safeguard money so that someone who is young or a spendthrift doesn't get money right away. Now the surrogate's office, when we've done programs with the county surrogate, they'll say, beware of online forms a lot of times because they claim that valid in every state, reviewed by an attorney, but the problem is that one size doesn't fit all, and a lot of times people don't sign it right or don't do it right, and if it's not signed right, etc., then the surrogate can't admit that will to probate. So you can try to do your own electrical work, like I tried to do one time. And if you do it right, you save money. But usually you see sparks coming out of the wall, and you say, I better get an electrician for this. You can watch a YouTube video on doing your own plumbing. If you do it right, you save money. If you do it wrong, you got water and bad stuff in your house, and you still got to hire the plumber. So, let's talk about, believe it or not, having wills and documents done has become easier in New Jersey, really because of COVID, because the idea is for people can get stuff done. The old system used to be someone makes an appointment in a law office, then they'd be in the reception area and they have a pen, they're like handwriting stuff out. And now what we're able to do is we can email out the questionnaire, and it's it's not that complicated. who's executor one, who's executor two, who gets your stuff. Believe it or not, New Jersey got reduced some taxes. Now for inheritance taxes, no taxes going to children, to spouse, to grandchildren, to parents. If it's going to charities, there's no tax. Now, by the way, South Brunswick has a library foundation, doesn't it?
We do.
Okay, so if it's going to it has to be a bona fide 501c3 charity. But you think about, some people say, listen, I'm not going to give a percentage, but I'll give whatever kind of my church, my library, whatever, some money, and it's there. So logistically, what we do now is most attorneys email out a questionnaire. Every once in a while, we have someone who's my father's 9 years old and he gets email in. And so he doesn't read them too often, doesn't respond, but he can read them. But some of the people say, oh, I don't have email. He goes, I bet get your kid or your grandkid has it. You go tell your grandkid who lives one town over that hasn't visited you in a while, goes, hey, if you come over and visit me in the next 2 weeks, I'm going to give you $5,000. Because that's what they were going to put in the will anyway. And if they say, no, Grandma, I'm too busy to see you, and you live 2 towns over, then okay, no problem. I'll give the $5,000 to someone else. I won't leave you anything. So, so the questionnaire really says, okay, what's your name? Who's going to be executor one? Who's going to be executor two? Some people don't have computers. So listen, families, help them. I just need to talk to them. Okay, I do not recommend joint executors. It really creates twice as much work. The idea is there's one captain of the ship, there's one president of the United States, and there's only one steering wheel. You can't have 2 steering wheels, and that's what, because we've seen when it's co-executors, that means that 2 people got to do everything together. And sometimes you get, client goes, I got 2 kids and they do everything together and they're good. I goes, yeah, but that means that they have to do everything together. Both of them have to go to surrogate's office, and both people got to sign the contract and sign everything together. It's better one. A client goes, Kenny, I just feel bad. I can't pick one over the other. He goes, you're not going to pick one over the other. I'd say, let me tell you what we're going to do. We wrote down the names on a piece of paper. We, moved them around, and I closed my eyes. He goes, okay, Abigail's going to be executor number 2. Your wife's executor 1. And when Abigail, when the other one says, why wasn't I executor 2? He goes, because the attorney closed his eyes and he has 2 pieces of paper. He picked one. If someone insists upon it, yeah, I do it. But I tell people, listen, based upon me having done this for 38 years now, I usually know what's best for people. And I had a client 2 weeks ago. He wants to come in and have an in-person appointment. He goes, okay, and I knew a little, asked him a couple questions. Okay, Mr. Shaw, let me ask you a question. Let's see, you're married. Are you looking to disown your wife? He goes, no. You want everything to go to her, right? Yes. Okay. You got 2 kids and neither of them are minors, right? Yes. Okay. Are you disowning either of your 2 kids? No, I want to treat you equally. I know what you need. You don't need to make it, you don't really need to make a trip into my office unless you want to drive on Route 1, which most people don't want to do. Okay. And so we ask people, okay, do you have real estate in New Jersey? Do you have real estate in any other states? Believe it or not, New Jersey is the probate easiest state in the country. I'd say other states are some states are very complicated. My mother-in-law used to call me up every other year. I want to come in and get a trust done. Okay. And I would ask her, were you watching Susie Orman on TV? And she says, oh, yes. And I goes, Susie Orman is exactly right. If you live in New York, California, Florida, if you don't have it's not having a trust done, it's having your trust done and your assets owned by the trust, not by you. If you live in Florida, New York, and the assets are not owned by the trust, you screwed your family, and it's going to take them 3 years and $15,000 for the probate of a simple condo in Florida. So the people with Florida condos are good. Set up a trust there, have it owned by a trust. But we do, that's why we ask questions about real estate. But I mentioned New Jersey reduced the estate tax, the inheritance tax. New Jersey did away with the estate tax. Now, there is a federal estate tax. That's $12.7 million. Okay, everyone in this room has that much money. Raise your hand. Nobody. I'm trying to think. Do we even know anyone that has $12.7 million? And if they do, they don't want you to know, because then everyone's going to be hitting them up for money. Now, we do point out, though, that even you can have the best will that was ever done, but certain assets don't get transferred by the will. They go directly to whoever owns it. So, for example, if it's a house's own husband and wife, the deed says that, automatically goes to the survivor. Will can't change that. If you have bank accounts that are POD, joint tenancy payable upon death, automatically goes to the survivor. Other assets passed by contract, IRA, 401k, life insurance annuity. Who's ever the beneficiary gets it. So what we remind people over to go say, get a copy of, get an old-fashioned printout and put that in the folder where you're going to keep your will. If your beneficiaries of these assets are different from what you have in the will, just so you kind of know, because and it's your right to do with your assets what you want. Say, Mr. and Mrs. M used to have a new will done every other year, depending upon their relationship with their daughter. One year she's in, and the next year she's out because she's dating the bum. And then they get, okay, now she's in because they're getting married. Then she's out, and then there's the first grandkids. So okay, now she's in, but then they're not having enough time. So down the road, let's say grandma passes, and they, had a client who says, you know what, I'm going to do a new will because, my one son passed, my daughter, she's got, I don't want to leave to her. And my grandkids have haven't seen me in 2 years. They didn't even come to their grandmother's funeral. Okay, fine, we do the new will, but he forgets to change who's the beneficiary of his 401k. So who's getting $350,000 tax-free? The grandkids that live the next town over that are in their 20s that don't visit grandpa. And then they're sad. Oh, I didn't know grandpa was sick. Well, maybe you should have visited. I mean, I'm different because I go and see my dad every couple of weeks and, make sure I call him every once in a while, as does my brother and sister. But, you give to who you want. Okay. Now, beneficiary. You're gonna figure out, okay, who's getting my stuff, and if any of those people pass, who gets their share. You don't want to have anything kind of dangling. Let's see. Now, let's talk for a second about specific bequests. By the way, I know I'm gonna stay around for some questions afterwards. Okay, so write down what your questions are. Who's gonna get your stuff? Many people have what are called specific bequests. Some people might say, listen, I want to give each of my grandkids $10,000 or $20,000. I mentioned some people put aside a specific bequest for a charity, like a library foundation, something that's close to them. When I did my first will, I think I gave $2,000 to my University of Scranton track team, and another $2,000 to my high school, cross country team, just so they could buy new uniforms, because the football team always got most of the money, and our uniforms were old and smelly. Some people have specific bequests of items. So sometimes the ladies say, you know what, I want my jewelry to go to my granddaughter because my son's the executive. He's just going to bring the cash for gold. He goes, hey, what do you give me for this junk, this stuff? Let's see. Some of the men had their valuable baseball cards or whatever, or hunting equipment. They wanted to go to someone that would actually use it rather than chuck it. You can think about specific bequests. Now, then we have what I call the reverse specific bequest, and that is I leave nothing to name a person. You don't give a dollar. It's not. You don't give any reason. Nothing. Just nothing to them. You don't have to explain it away because they kind of know why they weren't taken care of. Let's see. People ask me, can the person who's left out challenge the will? I goes, well, it's difficult to challenge it, and it costs money. I'd say, every other month, we get a call, someone was left out of a will, and they call us to challenge it. I go, okay, let me ask a question. The judge is going to ask you a couple questions, okay? In the 2 years before your dad passed, how many times did you visit him? Well, we had a falling out. Okay, that's 0. Okay, in the 2 years before your dad passed, how many times did you call your dad? None. Okay, did you any other contact? No. Well, sir, I think you're kind of wasting your money because you're not entitled to get something. Just like a client one time said, do I have to treat all my kids equally? He goes, nah, you do whatever you want. It's your money. If you want to leave it all to the cats or the dogs, that's your right. She goes, what's your concern? She goes, oh, one of my sons, he lives on the West Coast. We don't hear much from him. I goes, okay. Did he send you a card or call on Mother's Day, your birthday, or Christmas? No. Why would you leave 2 cents to this bum? Because he's a bum. And you know that's going to be the person that is going to be the biggest pain after you pass, because the day of the funeral is going to be, where's my money? The person that didn't visit or do anything? So, again, it's your right. Just, hey, nothing to that person. When there's minors or young kids, sometimes we'll say, okay, they get some when they're 22, some when they're 25, the balance when they're 30. Someone said, I'm going to make it 40. Okay, that's fine, because it's your right to. Sometimes we need to protect them from. I was like on the phone with a lady that goes, no, I want my son to get all the money when he's 18. I goes, why would you do that to your kid? Every single kid in that high school is going to know that he's getting $400,000 the day he turns 18, and he's going to get new friends. They're going to help him blow the money. If someone wants to do dumb stuff, hey, that's their call. But and you got the kid could be the valedictorian of the school, but if the parents aren't there to supervise and you give them a lot of money with no supervision, then the dark side comes in. You need to. It's like if you're left for the day and you put a 20-pound bag of dog food in the corner with a sign that says, dog, don't eat all this now. You come back and the dog will weigh an extra 20 pounds because the dog's eat the whole thing. That's how 18, 19-year-olds are. Some people, though, they have what's called a spendthrift trust, not for young people, but they could have a child that has, money problems, substance abuse issues, etc., where if you gave them the money outright, they would blow it. And the state hired us because mom had set up a will, but the money from one of the sons went into a trust for his benefit because he was an alcoholic. So there was a complaint motion filed to compel the trust to pay alimony that was owed to his ex-wife. The judge agreed. We went in front of the judge and goes, Judge, that's why people set up a testamentary trust, because, believe it or not, it's protected from Medicaid, it's protected from taxes, etc., because it's all discretionary within the right of the person who's the trustee. And that's not, again, that's why it's a good idea to discuss it with a professional who does this kind of stuff, not just get some cheap thing online. If someone calls me and asks me questions about stuff I don't do, I goes, hey, I'll steer them towards someone who knows that kind of stuff. Okay. If you already have a will done, a will that's done now is valid 5 years from now, 10 years from now. But sometimes this changes in the law. So make sure that if you do have a will, it's a self-proving will. Under the old law, the person signs and there's two witnesses. But then, after the person died, you had to locate one of the two witnesses, which sometimes like it was difficult to do. And I remember my grandma passed, was done the old way, and we find a witness. She goes, yeah, I can go sign a paper saying I was a witness, and my fee's $500. $500, that's more than what it costs us for the will. But otherwise it would cost us more to have to go in front of a judge with a complaint or to show cause. So the self-proving will statute, person signs, the two witnesses sign, and the attorney notary signs, and it's all done twice with some language that says self-proving will. And the surrogate often points out that when, they get sometimes things that people did that are not self-proving will, and they have to go say, hey, you gotta go get the witness. I don't know who that was. It was someone that was in the bank or the UPS store, etc. So make sure that the will is done is a self-proving will, and not some cheap thing online. Also, you want to make sure that it has a clause that says no bond is required. Otherwise, the executor has to take out spend a couple grand taking out the what's called a surety bond. Which, if you already trust the person that's become an executor 1, executor 2, why make the estate pay money? So logistically, how we do it, we email a questionnaire and someone types it up. I give them a call, I prepare the documents, I email it to them, and then they decide, hey, do they want to drive to our office on a Monday, Tuesday, Wednesday when we have witnesses, or do they want to go, on the weekend to the UPS store with, one of their friends is a witness, and the spouse can be the secondary witness on the will, but the person for the power of attorney, the person who's the agent or cannot be the witness. So, I'd say, how complicated was that on doing wills? It's not. So get your stuff. Don't be a putter offer. Don't be Carl. See, here's the story of Carl. Carl was this retired engineer, not a trained engineer, one of those like smart kind of engineers, but the kind of people that would read. If they got a new car, they would read the manual. When the computers used to have a thick manual, they would read it. So Carl wanted to have stuff done, or documents done, and he goes, well, I'd like to read more up on this. I go, Carl, you don't need to read anything. Let's say, I went to law school, I passed the bar, I attend seminars, I give lectures, I wrote a book on this. This is what I do. Well, I want to read more up. 2 years later, Carl's daughter calls him. Oh, do we have it? She found some of our pamphlets. Do we have his original will? Now, Carl wanted to read up more, and he never got it done. So don't be put her off. People say, here's what happens in the summer. I'm really busy. It's the summertime. And then it's the fall. I'm really busy in the fall. And then it's like Thanksgiving and a holiday. I'm really busy. Then it's the winter. Oh, it's snowing out. So put it off. Now, I mentioned briefly my mother-in-law and Susie Orman about having trust and stuff. I'll say yeah. So I ask people who say they want to have a trust, why do you think you need to have a trust other than Susie Orman in New York and California says it's a good idea? I don't. Why do you think you need to spend an additional $6,000 on having this done and you not owning your house, etc.? Was it a friend of yours in another state that did that? A revocable trust, I asked people why New Jersey probate is relatively easy and expensive. A revocable trust does not protect assets from nursing home or taxes. Some of these salespeople sell trust because, a trust is private and no one will know your business. Well, when a will, if someone dies, becomes a public record, but it doesn't list any assets. And unless someone's leaving their assets to some unpopular kind of group, why you care people know you're leaving it to, children and grandchildren. And so if someone says, I want to have a trust done, I want to put my house into a trust, then that's something that can be done. But not that many people have revocable trusts in New Jersey. Now, because, probates, other people though have what's called an irrevocable trust to try to protect assets from Medicaid, nursing home, etc. It has to be irrevocable. The person who is setting it up can't be the primary trustee. And for the purpose of Medicaid, it's a 5-year look back, 60 months. And, and when I really talk to people ask me, sometimes someone asks me, what did I do? Me, I'll say, I'm not spending all that money. Even if I, had to spend money, why do I want to not have the assets into my name so I'm penniless, so that if I have to go into a nursing home, there's no quality, there's no money, because there's nice nursing homes, and there's ones that are smell bad. And he goes, Jesus, I'm the one that worked hard. Let's say, I was a paper boy, I cut grass, I always worked hard. Why should I go into a crummy nursing home so my son, Dr. Brendan, can have a bigger boat? Now, at least that's me. Let's see. But some people said, listen, I want to have something for my kids down the road. Okay, listen, if you want to spend all the money and guarantee it, that's something that you can do, but it requires an irrevocable trust. Let's see. So that's what you need to, that's like some of the basics on wills. Oh, by the way, before I go on to living wills, if anyone attends any of our seminars, most attorneys charge a consult fee. If anyone attends one of our seminars and then they, discuss it, we email the questionnaire, and we waive the $200 consult fee if they contact us within 20 days. Some people have kids that are special needs. That requires specialized forms, because the federal government is very strict on that kind of stuff. Okay, let's next talk about the power of attorney. A will takes care of your assets if you pass away. A power of attorney is while you're alive. You're giving the power to someone, spouse, a child, someone you trust, to be able to help you out financially and to be able to do things that you can do legally. Get a power of attorney done. Once a week, we get a call. I need to get power of attorney over Mom, Dad, Uncle Joe, my brother, whatever. He goes, whoa, someone can't get power of attorney over someone else. They have to have affirmatively, signed the docket and given it to you. So, and we try to help out people that have some health issues, whatever. Okay, if we talk to the person, can they tell us over the phone, first of all, that they want you to be their power of attorney and be able to, pay their bills, etc.? If yes, then it's possible. If they say no, the person's in the hospital, I goes, well, then we can't do it. And otherwise, so if someone can't sign a power of attorney and didn't have one done, then the family has to spend thousands of dollars going through a complicated guardianship proceeding, ask a superior court judge to declare the person incapacitated. It used to be called incompetent. And again, they're looking at spending $4,000, whatever, and having to, go through the court system. Having a power of attorney is the better thing that it's there. Now, power of attorney is effective either right away or only upon disability. If it's effective right away, it stays effective even if someone becomes disabled. That's called the durable power of attorney. Some people want a power of attorney that's only effective if they become disabled. That's called a springing power of attorney. Once again, my client Bob, he goes, Kenny, he goes, I'm a carpenter. I don't understand this legal jumbo. Explain to me in carpenter language. Okay. If the power of attorney is effective right away, your son can steal all your money right away. This is the one who's going to pick. If it's effective only upon disability, he got to get a note from a doctor before he steals all your money. Knowing that, you trust your son. He goes, oh, I trust my son my life. Make it effective right away. No need to make it more complicated. Now, The surrogate also says, don't use cheat forms online because they're just general for every state. It doesn't have New Jersey specific language. Some of the banks and institutions used to give people a hard time. And they say, oh, it wasn't done in our Wells Fargo form or, whatever. So New Jersey's legislature came out with a statute that says, hey, if they're doing business here, and it makes reference to New Jersey statute, then they got to honor it. However, the New Jersey statute is Section 2 of PL 1991, C-95, 2B, or 46:2B-11, and the cheap things online don't have all this. Every other year, we've been updating our documents. We even put in a HIPAA authorization in our powers of attorney and living wills. We recommend it be effective right away. Here's something kind of new. I tell people this. It's a good idea to sign a new one every 5 years. I go, not because I'm making a whopping extra $100, but because a lot of times some of these banks or institutions says, well, that's kind of old. That's 15 years old. How do we know that the person, that's still effective? What we do recommend people do is after they sign the power of attorney, scan it or make a copy and give it to their financial advisor, their accountant, anyone that they do financial business with. That way, it's in that financial advisor's record. So if the day comes where it has to be acted upon, it's not the first time that they knew about this. So you want to get, now, a will does not need to be updated over the years unless who you want as your beneficiaries change, or is the executor no longer able to do the job? Our rule of thumb on the executor is, can they drive to a bank and walk up a flight of steps? We're not anti senior citizen, we're practical, because the county surrogate's office in New Brunswick, there's no handicap parking within 2 blocks. Then you got to walk up a hill. And my grandfather was the executor of his cousin's will when he was 95 years old, because I guess from walking up a 5-story walk up with no elevator, that kept him fit. But you think, can the person still do the job? Okay. By the way, some people through their work and business, they have what's called legal insurance, legal plans. So in New Jersey, some of the big ones are MetLife Legal, ARAG Legal, Legalese. Some of the retired auto workers have the UAW legal plan. So we do documents through that as well. The last thing I'm going to talk about is the Living Will Advance Directive. Okay, so your will takes care of your assets if you pass away. The power of attorney gives the person the power to help you out financially. The living will is that document where you're saying to hospitals, doctors, the world, listen, if I am so sick that I can no longer talk and I will never talk again, and there's no hope for me, and it's just a matter of a week or days, whatever, do not use artificial machines and means to keep my body going if there's no hope. The living will is not for you as a signer, it's really for your family, so the doctor doesn't have to ask the family if there's no living will. Okay, should today be the day? Should we remove life support? Because I remember one time a doctor asking me that. I wasn't even a family member. I was the power of attorney, but okay, should we remove life support? I remember saying, geez, doctor, I feel bad. I mean, the right decision is for someone who's 92 years old that's not going to open up their eyes again, but you hate to be the one to say, okay, yeah, go ahead. Turn the switch off. Yeah, go ahead. So that's why we encourage people to have the living will. There's advances in science, etc., keep someone's body going, where there's, then they'll never wake up again. Okay, the living will. There's a section, fluids and nutritions, withheld or provided. 95% of people say withheld if there's no hope. Other medical treatment, artificial machines, 99% of people say that. Now, I don't want anything done. Similar to the power of attorney in the will, you have someone who's going to be your agent. It can be someone different, and in your family, someone that has some medical, knowledge. But you also want to be someone that's going to kind of follow what your wishes are. Now, for the married people, you remember when you're first married, you're all lovey-dovey and stuff like that. So my wife and I we got married 34 years ago, and we're redoing our document. I'm redoing my will and living will. She goes, "Oh, I could never let them, remove life support because you're all lovey-dovey and stuff like that." I go, "Okay, fine. I'm just gonna leave my dad because he's logical like Mr. Spock." And he would say, "Hey, if Kenny doesn't want machines, then that's what we do." So 25 years in the future, my wife goes, "Wait a minute. So if you die, I get $800,000 tax free, and I don't have to work anymore or teach anymore." He goes, "Well, why can't we do it right now? Pull the plug on you." Well, I still got a couple more good years left, I said. So, and after you sign your living will, you give it to your family, you give it to your doctor. So, and I also recommend people sign the organ donation part. Interestingly, I went to a seminar that was put on by the NJ Cherry Network. They're the ones that deal with organ donors. I goes, "Hey, what's the maximum age to be an organ donor?" And he goes, "There is none." He goes, "Really?" He goes, "What's good on an 85-year-old guy?" And he goes, "Skin and cornea." I goes, "Oh, well, I never thought about that. I'd rather have old guy's skin than like if I was in a fire." So we have a website, njlaws.com. If you type in almost anything in the search button, there's an article or something that's there. But again, the last thing I'm going to say before I turn it over to my colleague Dan Fabrizio, don't be a Carl. Don't be a putter-offer. Get your stuff done. Don't say, "Oh, I'm going to keep on reading up on this," because it's, when I had my knee surgery, I didn't read anything about how the doctor was going to do the knee surgery. I don't want to know. I'd say, I go to the doctor. It was the Rutgers. Whenever I had a new orthopedic issue from all my sports, I would call Rutgers track coach. "Hey, who are you sending your guys to for whether it's a knee or a foot or an ankle?" They're all specialized. He goes, "Oh, So I go, "Doctor, you've done this before?" He goes, "Kenny, I can almost do this in my sleep, but they frown upon you doing surgery in your sleep, so I'll stay awake for yours." Okay, good. So with that, my name's Ken Burkham, and I'm going to bring up Dan Fabrizio, who lives next door in Princeton Junction, to talk for a little while about some mistakes that he sees people making. Thanks, Dan.
You got it. Thank you, Ken. Good evening. My name's Dan Fabrizio.